a professor of law at Suffolk University, who has recently posted a session on defining what effective legal language is. So I have a few questions for Gabe after watching the session, which you can access on legalhackathon.org. And the first problem that I've sort of identified with this question of legal language is, are we looking to correct the verbose, unclear, and ineffective legal language at the legal drafting stage once the law has been published, or at both stages?
Well, ultimately, it's an important part of the process to make sure that at the drafting stage, the language is appropriate for the context. And what that means is that the language has to be set up in such a way that it meets the audience's needs and expectations. So when we talk about this challenge, one of the things that we're talking about is the importance of making sure that at the drafting stage, we make sure that the language works. But as a second part of this problem, we should look critically at existing law and think about ways that we can improve it. Ultimately, it's an important part of the process.
Great. So another question I had was something you brought up in, I think, the third or fourth section of your video segment. And you mentioned that courts often look at legal text and attempt to interpret the original intent of that legal text. So can plain language drafting improve the process by which courts attempt to interpret original intent of the drafters? And if so, could you elaborate a little bit on how that might work?
Sure, that's a fantastic question. So the question of how do you deal with the way that courts are going to look at existing legal language? Because as legal drafters, we have to anticipate not just an audience of the public for reviewing this legal language, but how the courts are going to deal with it if there's litigation, if somehow the law is ambiguous or the rules are broken. So one of the things that we can do is we can, ahead of time, as we draft legal language, anticipate how the court will respond to it. One of the best ways to do that is being cognizant of the way courts behave when they look at legal language. So we can add the intent of our language right in there. We can add a preamble that says, here's what we're trying to accomplish, here's what we're trying to avoid by this rule, regulation, or in the private scheme, contract. These are the things that we have in mind, and that can help subsequently guide courts, because courts tend to defer to the people that created the legal language.
Okay, yeah, that's actually a really interesting aspect of it, of sort of creating a preamble that really clearly and plainly and effectively outlines or describes that intent. And one final question I have for you is, what are some audiences that you feel need access to plain, effective legal language the most?
Sure. So in terms of thinking about what audiences need plain, effective legal language, of course, the most important audience is the community that's being ruled by the rule or regulation or contract. In other words, people, as a basic fundamental principle, should have a right to be able to not only have available to them, but actually understand the rules that guide their lives. So when legislators act, when regulators regulate, when people form contracts where there are different levels of sophistication and power, it's really important that the person on the receiving end of that information, the member of the public who's going to be subject to that new law, is able to understand what it means. So we can do a good service for the community as well as within the business community if we think critically ahead of time about how to draft language so that the people, the end users of that language, the people that are governed by it, are able to make sense of it.
Okay, great. Thank you. Thanks a lot, Gabe.
Thanks so much.
Great.